Now, we are going to be dealing on the topic. I marked this topic because of what happened recently. Of course, we pick information and we digest them the way they are, unbiased, undiluted. Yes. Of course, we noticed what happened last week, wherein about 76 persons were arraigned before the Federal High Court, Abuja, and out of these 76, 32 of them were minors. All right, yeah, they are juvenile, and of course we know what happened. The human rights groups and the human rights activists were dissatisfied by the attitude of Nigeria Police Force to have arraigned the minors before the regular court, which is the Federal High Court, Abuja. It was a very shameful thing to have happened here in Nigeria, where it brought shame to our criminal justice system and the image of this country in a whole. Of course, Mr. President Bola Ahmed Tinubu swiftly responded and informed the Attorney General of the Federation to quickly release those children, those minors, to their parents without further delay. And then, of course, we blame the police who also investigated. And before then, we also don't forget that the police has gotten order, the police got order from the court, from the High Court, or from the High Court, to remind these children, and they were in custody for 3 months. That was another, contravention, infringement to the right of this juvenile. You don't detain them in the police facility, detention facility. It was a very bad one for Nigerian police, But then somebody called and asked inbox that if the Nigerian police has right to initiate charges against these children, and then of course forward it to the Federal High Court. I said yes. Nigerian police has the right to charge any criminal, any alleged criminal, to court based on the offense he or she may have allegedly committed. The Nigerian police has that because they have the legal department. And we also know that Attorney General of the Federation also can arraign. But here, police arraign these suspects, these 32 juvenile, alongside. In fact, there were 76 in all, but 32 among them were said to be juvenile. And the question is, does the Federal High Court have the right to try these children? The answer is no. The answer is no. That charge pressed against these persons were wrongly instituted before that Federal High Court, because the Federal High Court lacks the jurisdiction to try these juveniles. The juvenile should also be tried not in the regular court, but in the family court. Yes, that is the family court, according to the Child's Rights Act of 2003. Of course, Section 149 has empowered the family courts to try these juveniles, and they shouldn't be tried in the regular court. So the family court has the power to look into the criminal matters that was pressed against these children. And of course, they were charged for treason, and they were also charged for intent to destabilize Nigeria. And of course, also, they were also charged for mutiny, to have called Nigerian soldiers to take over the government of President Bola Ahmed Tinubu. So these were some of the charges the Nigerian police pressed against this juvenile, was wrongly pressed before the Federal High Court, Abuja, which was wrong. On that note, Mr. President ordered the Attorney General to take over the file and do the needful. So the law is that the children should be tried before the family courts. Because of course, you know, the family court has the wisdom, the knowledge, the understanding, the charisma, the jurisdiction to adjudicate into the minors' criminal issues as allegedly charged. And of course, the punishments should not be the same punishments of an adult charged before the regular court. The punishments that differs. You know, of course, here the children, their punishments may be rehabilitation, to rehabilitate them into the society with little caution. You know, because they are children, they are below 18 years and shouldn't be detained in the normal detention facility. Of course, when you bring them to the correctional center will reject them because they have no place to be there. And having said that, if an arrangement must be made, if a detention order must come, it must be on the family court will have the discretion to decide of which detention facility these students should be and what conditions should be placed them. So we are looking so malnourished that it was like they were convicted already facing punishment, and which is wrong. Remember, an accused person brought before the courts still is innocent of that offense until the contrary is proven. So these children were looking so malnourished, like they were starved these 3 months that they have been in the police custody. These are the areas where our criminal justice system from. And we have a good criminal justice system, and thank God the Attorney General has taken over that matter. Police also have learned, and on this note, the police should know that wherever the detention facility of Nigeria Police, where juveniles are detained, of course, should be released without further delays, and the needful should be done. And also, the charges will be taken over by the Attorney General. But that doesn't mean that the children have gone scot-free. That doesn't mean they didn't commit any offense. But detaining them and bringing them before the Federal High Court was what we found